almost a week since Shiv Sena leader and Urban Development Minister Eknath Shinde raised the banner of revolt. But so far, Shinde's political plans aren't entirely clear yet. Neither has his rebel faction with its alleged 37 MLAs, nor has Maharashtra Assembly's single largest party, the Bharatiya Janata Party, made any attempts or any moves so far to make Chief Minister Uddhav Thackeray prove his majority on the floor of the House. And it is the anti-defection law under the constitution that is actually standing in Shinde's way, and that's what we'll be talking about in today's episode of KYC or Know Your Constitution. Now, just to begin, you must have heard the phrase Aya Ram Gaya Ram. It actually became popular in Indian politics after Haryana MLA Gaya Lal changed his party twice within a few hours and thrice within a fortnight in 1967. Naturally, the need for a law to prevent such a situation arose. So the Rajiv Gandhi government finally stepped in and brought a bill to amend the constitution and curb defections in 1985. The 10th schedule of the constitution, which contains the anti-defection law, was added to the constitution, like I mentioned, through this amendment in 1985. Now, according to this schedule or this law, an MP or an MLA is understood to have defected if he voluntarily either gives up the membership of his party or disobeys the directives of the party leadership on a vote. These are basically the two conditions on which he can be considered to have defected. But the 10th schedule lists down one instance where the legislators can change their party without risking disqualification, and that is paragraph 4. So paragraph 4 of the schedule allows a party to merge with or into another party, provided that at least 2/3 of its legislators are in favor of the merger. It's a little complicated. So in such a scenario, neither the members who decide to merge nor the ones who stay with the original party will face disqualification. And this is the exact provision that seems to be standing in Shinde's way. What this provision means basically is that there are two conditions that need to be satisfied to escape disqualification under paragraph 4. One is that there should be a merger between two original political parties, and then subsequently 2/3 of the members of that house belonging to that party should accept the merger. If 2/3 of the members do not accept the merger, then the merger doesn't happen as per the law. So both these conditions need to be satisfied. According to experts, this provision has been made so difficult so that ambitious members do not break up the party just because they have 2/3 majority. Because the anti-defection law also aims at protecting the party system and not just curbing defection. So the law ensures that Shinde has very limited options. In order to avoid disqualification, he must either prove before the Speaker and the Election Commission that he has the numbers to be the original Shiv Sena. That's his first option. Or the second option, that he is willing to merge with another party. Now, to prove the first option, that is to prove that he is the original Shiv Sena, in fact, Shinde would have to show that he's been able to split the party vertically. This means that not only does he have the support from the legislative party, but also among MPs, contractors, and executive and district units. Experts claim that this looks very unlikely because Thackeray has been rallying the party cadre on the ground. As for the second option of a merger, that isn't too clear yet so far as well. Now, in any case, just to give you an update, the matter has reached the Supreme Court. The rebel MLAs were issued disqualification notices, as we know, and were given 48 hours to respond. These 48 hours were to end at 5:30 p.m. on Monday. But before that could happen, Eknath Shinde moved the Supreme Court instead, challenging the notices on various grounds. Now, the Supreme Court on Monday extended the time for the rebel MLAs to file their responses to the disqualification notices. So, as per the Supreme Court's order, the responses have to be filed by 5:30 p.m. on 12th July now, which is a long time. The court has also granted time to the respondents in the petition to file their replies within 5 days. And the matter will next be heard on 11th of July. So the rebel MLAs have definitely bought some more time for themselves, if nothing else. That's all I have for you for now. This is Apurva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.